Good afternoon, everybody. Thank you for joining us for the final webinar in the 2017 edition of Conn Maciel Carey's OSHA webinar series. We have, maybe I'm speaking only for myself among my colleagues, but we have really enjoyed this webinar series this year. Great interaction with participants, lots of wonderful questions, lots of follow-up after these events, and a whole lot of hard work putting these together and putting these on. But it forces us to pay attention to developing issues in the OSHA space, keeps us current, and we've really enjoyed it. We have saved, I would say, not the least for last, as we cover OSHA's Process Safety Management Standard and EPA's Risk Management Plan Rule in our December 2017 webinar. The plan today is to provide a regulatory update talking about the various rulemaking activities in the PSM and RMP front, as well as what's going on in the enforcement context. And really, as we transition from the Obama administration to the Trump administration, what does the future of process safety management look like? I'm pleased to be joined today by my colleague Micah Smith. I'll let him introduce himself. I'll tell you a little bit about myself, and then we'll jump right into the topic. My name is Eric Conn. I'm the chair of the OSHA Workplace Safety Practice Group here at Conn Maciel Carey. My practice focuses essentially exclusively on workplace safety and health law issues. And there is, today, I'm excited to share that one little sliver of environmental law where I will dabble from time to time, and that is the Risk Management Plan, Section 112A of the Clean Air Act, because it is a sister regulation to OSHA's PSM, where I spend a great deal of my time. I represent employers in inspections, investigations, and enforcement actions involving OSHA, the state OSH programs, the Chemical Safety Board, MSHA, and again, EPA in this one tiny little area. We work with employers, again, through investigations, but also through the entire litigation and enforcement process, including, unfortunately, more and more these days, criminal prosecutions and investigations for worker safety-related matters as well. I write and speak regularly on workplace safety and health topics, conduct training, develop compliant safety and health programs, and work with my clients on general compliance counseling as well. And I'm pleased to be joined today by my colleague Micah Smith, who is a true process safety expert.
Thanks, Eric. Yeah, so like Eric, focus on occupational safety and health law exclusively. Process safety management is near and dear to my heart. I've been doing PSM work since literally day one of my practice of law. So we've represented a lot of great clients through a lot of bad situations, some of them as a result of unfortunate accidents, some as a result of, let's say, vigorous prosecution by OSHA. Like Eric, I have worked on all kinds of litigation and client counseling. So if you have an OSHA issue question or an active matter, happy to help however we can.
All right, so let's review the agenda real quick and then jump right in. We are covering today really the regulatory landscapes. That includes what's been going on the rulemaking front on the RMP and PSM side. We're going to cover some significant decisions by the OSH Review Commission interpreting those rare PSM-related OSHRIC decisions, so we'll give a little guidance on what direction the Commission is going in some significant PSM cases, and then talk about the enforcement context. And the biggest development from a PSM standpoint in enforcement is the launch, essentially right now, of the new ChemRef, the Chemical Facilities and Petroleum Refinery PSM National Emphasis Program inspections. We'll talk about what employers can inspect under this new program, or really this retooled program. And then, importantly, as we gear up for inspections under that program, we're going to take a look back at what lessons could be learned from the first wave of inspections that were conducted under the PSM National Emphasis Programs, so that we might apply some of those lessons as we gear up for a visit from OSHA or one of the state OSH programs. So starting off on the rulemaking front, let's talk about EPA. And the reason why it makes sense, I think, to start with the EPA RMP rulemaking is that they actually got somewhere. They actually promulgated a rule, published a final rule in the Federal Register to amend the old RMP regulation, and then things took sort of a twist and a turn as the new administration took over. So we'll talk a little bit about that rulemaking process. We'll talk a little bit about the rule itself, and then we'll talk about the future of the rule. And this really was all driven by the West Fertilizer, the very tragic incident at the West Fertilizer facility, which prompted an executive order by President Obama to a broad swath of regulatory agencies, among them OSHA, EPA, Department of Homeland Security, Department of Transportation, and others, to take a hard look at the way the federal government has been regulating and enforcing and developing guidance on process safety management, on process safety issues, and essentially directed them to advance and amend and improve the way the government is involved in regulating process safety. And so this steering committee of multiple agencies got together and did a bunch of things to advance that executive order. OSHA issued some interpretation letters. Both of the major agencies involved in process safety regulation, OSHA and EPA, began the rulemaking process. We saw some new policies implemented, and we've seen this updated emphasis program from the enforcement standpoint. But what EPA did, among those things I just discussed, was they committed to updating and finalizing amendments to the RMP rule during the Obama presidency, which meant really moving quickly and moving through a rulemaking process in about 1/20th the time that it usually takes to promulgate significant rules like this. So they moved quickly, and in July of 2014 issued a request for information regarding 21 possible amendments, expansions, extensions, reinterpretations of the RMP rule. And the RFI process is step one of a rulemaking, soliciting feedback from interested stakeholders about some possible changes the agency is considering. It's not regulatory language, they're just concepts and ideas. And this umbrella of 21 topics was a pretty broad approach. Looked like a very, very significant overhaul was in store for the RMP rule. Feedback was taken from that RFI, and as a result of that, the agency put together a package for small business review, the SBAR process, EPA calls it in its rulemaking. And this process began in the summer of 2015 and continued through the spring of 2016. And what we learned through the SBAR process was that all of these amendments were on the table. And additional feedback was being taken from small businesses, and these would be small chemical manufacturers, small petroleum refiners, unions that have employees present at these facilities would have input. But in this small business review, making sure that whatever rule that EPA crafted would not be unduly burdensome on small businesses. At the end of the small business process, EPA published in the Federal Register a proposed rule. And what was really interesting, a couple really interesting things about that. First, the proposed rule pared down the topics that EPA was looking at, including looking at during the SBAR process, from those 21 original topics down to 6 topics for the proposed rule. And, I think the reason we were hearing from the agency is that they were trying to hold up their end of the bargain to get a rule done during the Obama presidency, and getting a rule done that has 6 elements as opposed to 21 elements seemed to be more realistic to the agency. It could be more efficient with a smaller subset of changes that they were making, and I think with the intent to go back and revisit these other elements, either through the OSHA rulemaking that was beginning around the same time but trailing EPA's rulemaking, or just revisiting again by EPA, presumably under a Clinton administration, I think was the thought process at the time. The other thing that was really interesting about the proposed rule that was published in the Federal Register is that it was published in March of 2016 before the report from the SBAR panel was even received by the agency. And you see the title of these slides. We've got multiple slides here on EPA's rushed rulemaking. And this, to me, was one of the worst examples of how rushed this process was. That if you're going to, by law, solicit feedback from small businesses and make sure that your proposed rule does not do such damage to small businesses that it drives small business out of the market, you ought to wait to get the feedback from small businesses before you propose your rule. And they didn't do that here. And first, I think that was probably a fatal flaw in the rulemaking, which would have, I think, given significant rise, meaningful rise to a legal challenge by industry to the final rule, but we'll talk about whether that has become moot in any event. But it did show that EPA here was destined and driven and motivated to get a rule done before the end of the Obama administration, and they were running out of time. So in spring of 2016, they published the proposed rule in the Federal Register, and also, very significantly, in that same month, the same month that the proposed rule hits the Federal Register, they also schedule 2 hearings for public comment in a hearing setting, in addition to the written comments that would be solicited. That is the only time I'm aware that the hearings were scheduled in the same month that the proposed rule was published. And despite requests for extensions at every stage of the rulemaking, including extending the SBAR process, extending written comment period for the proposed rule, and extending and indeed requests to add additional hearings, public hearings to the proposal process, all of those were denied, and denied because the agency was hell-bent on getting a final rule published before the inauguration of the next president. The minimum statutory period to solicit comment and to hold hearings was held, and on the day that period ended, the rule was rushed over to RMB for final review and approval of the proposed rule. And OMB took about as short a period of time with this rule as I've seen them take with any rule, and a final rule was then published on January 13, 2017, magically 1 week before the inauguration of President Trump. The final rule published did include all 6 of those elements, and it included an initial effective date of March 14, 2017, also a very hurried and rushed implementation period for employers, we think, again, to try and perhaps get this done before the new administration could take a hard look at this and make any change. Talk just a little bit about what was in the rule. We did a program on this topic last year, and I'm happy to direct you to a link to a recording of that where we went through these 6 elements of the amended RMP rule in great detail. I'll tell you just a little bit about what was in there. If you look down at the 3rd category, the safer technology and alternatives analysis, this is the element of the RMP amendment that probably caused the most heartburn among operators and employers. And this was going to be essentially adding a whole new process hazard analysis to the PHA process, where you analyze the availability and the feasibility of alternative chemicals, alternative technologies, alternative equipment that might be inherently safer or safer really in any measure than the technology and the chemicals that are already in place in your process. And the idea here is that you're implementing this as part of your PHA process, which means it's an ongoing analysis during the life of the process. And I emphasize that because that's a real big deal. It's one thing to do this type of engineering analysis before a new process goes online. It's an entirely different ballgame to look at this in the life of the process and talk about replacing the chemicals that are used, replacing the equipment that is used, making this a significant burden and a great challenge for employers and operators. The other elements of the rule that caused some heartburn was the public information sharing. There was a great deal of concern about having out there accessible to terrorists and ne'er-do-wells exactly what dangerous chemicals are on site, where in the process they are, in what volumes, and how the facility could be significantly impacted by events like attacks on the facility or accidents at the facility. So there was some concern about how this information would be shared publicly and how much information would be shared publicly, as opposed to what's being shared with emergency responders, which does have obviously a significant and important role. Other elements that caused some concern, a great deal of concern from my perspective, was the requirement that EPA was introducing for third-party compliance audits. In other words, saying the 3-year cycle compliance audit that's already been part of the PSM and RMP programs would now be required to be performed by a third party who is most likely less knowledgeable about your facility, less knowledgeable about your processes, and by the way, there's not a real glut of great talented third-party auditors out there, and that pool would be significantly impacted by the way that EPA defined independent third-party auditor. Independence in this context would mean that engineering firm, that consulting firm, that auditing firm would not be permitted to have performed any significant process work, engineering work, business for the audited entity, the refinery or the chemical plant, for several years leading up to the compliance audit, and no work for that company for several years after the audit. The problem with that is most of the engineering firms and consultants that we talked to about this said, hey, the real money for us is in the engineering work. It's in implementing recommendations and doing major projects for employers. It's not the audits. So if we are forced to forego engineering work, if we do audits, we're just not going to do audits, further limiting the pool of available and effective auditors. We also feel like the agency did not demonstrate and really made no significant effort to demonstrate that third-party audits were more effective or better than first or second-party audits. So we took some issue with this element of the rule. Finally, another element of the rule was changing the way that incident investigations were conducted by employers. Expanding what types of events required the regulatory required incident investigation, and then mandating a specific type of incident investigation, a root cause analysis, as opposed to the panoply of available investigation methodologies that are available to employers now under this performance-oriented standard. So that was what was proposed, not proposed, but implemented as a final rule set to become effective in March of 2017. Well, the new administration did act quickly enough to impact that effective date. At first, in the opening days of the new administration, Congress, under the direction of President Trump, analyzed the RMP amendments under the Congressional Review Act to consider a repeal that would bar the agency from ever promulgating a substantially similar rule. But that process, the Congressional Review Act process, has a very limited window of time, 60 legislative days, to be able to repeal an agency regulation by joint resolution of Congress, and it did not move fast enough or far enough through that process to be repealed through the Congressional Review Act. So instead, industry stakeholders filed with the EPA a petition to the agency to stay the implementation of the rule and reconsider the rule. And that petition included not only industries, but 11 states as well, states through their Attorney General's office, suggesting that this was a bad rule, bad policy, significantly more burdensome and expensive than proposed and included in the rulemaking package, and with significantly smaller and, in fact, some instances, negative positive impact on safety or environment. That petition was granted by EPA, and EPA delayed the implementation of the rule for multiple years. Initially, a delay to June of 2017, and then an extended delay out to February 2019. So for that sort of extended delay of implementation of the rule, EPA felt it needed to do this through the rulemaking process. And so they proposed a rule to extend the implementation period to allow the agency time to reconsider either some of the nuances of the amendments or the amendments altogether. Hearings were held on the appropriateness of the delay. Public comments were taken on the appropriateness of the delay. And EPA felt that through those hearings and through those comments that their delay was justified and implemented it as a final rule, published in the Federal Register, a delay to February 19th, 2019, a 20-month delay of the implementation, which feels about to be the amount of time it would take to go through a rulemaking process to revisit, again, either elements of the amendments or to repeal, rescind the elements altogether. I don't think there's any consideration to repeal the RMP rule itself. It was really to repeal or evaluate possible amendments to the elements of this amended RMP rule that were promulgated in a rushed fashion at the end of the Obama administration. That final rule, the final rule to delay the final rule, was challenged in court by environmental groups. And that challenge is underway right now. I believe just this week, or I guess actually it was last week, I believe the motion to dismiss the challenge to the extension of the rule, it became fully briefed, so we may get a ruling from the court, the D.C. Circuit Court, on the appropriateness of this delay, perhaps this winter. So we'll see if that delay, at that point, if the delay is found to be an unlawful rule, then the amendments would go into effect, but that would not stop the agency from undertaking a new rulemaking to analyze amendments to the amendments or rescinding the amendments or doing something different altogether. But it would mean that these 6 elements we talked about would go into effect. So we're paying close attention to that challenge right now. Talk real briefly about OSHA's, we'll call it sister rulemaking or parallel rulemaking to amend the Process Safety Management Standard, and we held this for second because it was quite a bit behind where EPA was. OSHA initiated a similar request for information, actually put out their RFI before EPA, but OSHA doesn't really have the same resources, rulemaking resources that EPA does, so they lag behind in the actual rulemaking process. They did get to the point last summer where they convened a SBREFA panel. This is the OSHA's version of the SBAR process, where small businesses, small chemical manufacturers, and petroleum refiners were able to provide feedback and comment about 20 generic issues, again, not proposed rule language, but concepts. There was considerable overlap in those 20 issues with the 21 issues that EPA was looking at, a little bit of divergence, trying to clean up some issues that OSHA has been trying to tackle for years since they've lost some key cases, like the interpretation of atmospheric storage tank exemption and exemptions for oil and gas drilling and servicing. Those would be unique to the PSM rulemaking, but by and large it was the same concepts that EPA was looking at, but essentially it got as far as the SBREFA process before the election and before the Trump inauguration. Then we saw this summer President Trump's first regulatory agenda, and interestingly, it seemed to me that they renamed this agenda. It may be just that I never noticed it before, but the name of this agenda that was put out by the Trump administration was the Unified Agenda of Regulatory and Deregulatory Action. So it's not just an analysis of the agency's rulemaking priorities for new rules, but looking at rules to either remove from the agenda or rules to repeal within the active final set of regulations on the books. And I bring this up because process safety management was addressed in President Trump's first regulatory agenda, and it was included in the package of items that were moved from the active rulemaking agenda to what's called the long-term actions element of the agenda, also known as the back burner. And these back burner rules are rules that effectively are indefinitely delayed, that we would expect to see no progress on these rules whatsoever until they are removed from this long-term action category, most likely meaning that we'll see no movement on these rules during the current administration. And there was the process safety management reform that was underway, and through the SBREFA process in the long-term action category, along with a emergency response and preparedness rule that sort of went hand in hand with the elements of PSM as EPA was looking at similar aspects of emergency response and preparedness. So on the OSHA front, we don't expect to see any further progress on this rule during the Trump administration. And on the EPA side, the progress we expect to see will be a proposed rule sometime in the near future that either proposes to rescind all of the new amendments to the RMP rule, or at least dances around the edges and softens some of the changes that were finalized in the final days of the Obama administration. So now we'll move over to what's going on in on the litigation front that sheds some light on how the decision-making bodies feel about process safety management with some recent PSM cases.
All right, so you'll see we tagged this as recent PSM cases, but if you follow closely in the news, you're going to be very disappointed about the lack of new news here. We're using the term recent pretty broadly because of how slow things tend to move in the OSHA and OSHRC front. So not a lot of breaking news here, but this is particularly important because we are, as you've seen with the lack of a new rule and the breakdown in progress in the PSM rulemaking, we have to live with the jurisprudence that we have here and the rule that exists. So this is going to be a review of the law as it exists right now. There are three recent cases here. We're going to talk about Wynnewood Refining, Delic Refining, and the Bp Husky refining cases. This analysis is particularly timely because we finally have a body of 3 commissioners. There should now be no reason why the OSHRC cannot move forward and actually decide the 2 of these cases that are currently pending before it. All right, so we'll get right into it. The first case to talk about is Secretary versus Wynnewood Refining. This involves a 2012 or 2013 incident where a boiler exploded during a turnaround at the Oklahoma refinery. A particular note here is the fact that this explosion occurred in a boiler inside a utilities unit. So this is not what we would typically consider to be a process unit. It also occurred during a turnaround when the plant was shut down. So a couple of key facts here that we'll talk a little bit more about in a minute. As I said, it was a 2012 or 2013 Citations. The case went to trial. We got the judge's decision in February of 2016. That decision was a mixed bag for the employer, and it was appealed on essentially all issues to OSHRC. Briefed last year, and I believe that briefing occurred in August of 2016. So we're a year and a quarter into our wait for a decision from OSHRC on this case. The 2 primary issues to talk about here, or the 2 key facts that are in play in this case, were the location of the incident in a utilities, a non-process unit, and the fact that the ownership had recently changed hands, that Wynnewood had only been in possession of the refinery for about 9 months before the explosion happened. All right, already flagged that this was its own unit, not a process unit. It was located near the cat cracker. It did not process any highly hazardous chemicals. It did use refinery fuel gas for fuel. The facility's PHA, a facility siting study, had determined that it was not close enough to a process unit to be co-located. Nevertheless, the ALJ did conclude that the PSM standard should apply, and actually his analysis covered a few different bases. We've got him tagged here. He did seem to want to make sure that he had multiple ways of concluding that the PSM standard applied. Some of the more striking were the fact that the connection of steam lines and fuel gas supply between this and process units, that was enough for the PSM standard to apply, despite the fact that there was not a threshold quantity of highly hazardous chemicals. There's a lot of discussion about potential releases and whether the boiler unit played any role in stopping a release or causing a release. And then the last point there that he made was that during the explosion, at a ladder that had been near or in the boiler unit had flown very close to or possibly maybe struck a piece of equipment in the FCC unit. Not enough to damage it, but certainly enough to show that flying debris could reach that unit. The last element there that he relied on to apply the PSM standard we consider to be pretty concerning. It was the fact that the refinery voluntarily implemented PSM-type elements. So probably for any of you that have PSM-covered facilities, I've seen many of our clients do a PHA for their utilities unit or units. There seems to be no basis for applying the PSM standard, but once you've seen the benefits, the safety benefits that you can derive from doing a process hazard analysis, it just makes sense that you might want to do that. So it was concerning that the judge considered this voluntary effort on the employer's behalf to show. He claimed essentially that it was an acknowledgement that the PSM standard should apply, and now that they were in court, they couldn't go back and reverse all that. So that's certainly concerning. So the net effect here is a bit of a surprise to those of us who've been doing PSM work for a while. We typically would almost never consider a utilities unit or a boiler that is not processing highly hazardous chemicals to be to require PSM compliance. Certainly, you have the option to do it, but for employers to have to work that into their PSM program is not something that really anyone in industry had been clamoring for. So this is a new development. As we noted, this case is on appeal to Osha. We could see a decision anywhere from tomorrow to 5 years from now. So this will be a good one to watch. We also flagged here that Osha had applied a very expansive successor liability theory. Several of the citations issued to the company were repeat citations. They were based on citations that had been issued to the previous employer. It's always a sensitive issue when you have a change in ownership about how much of the previous owner's conduct the new owner will be tied to. In this case, Osha considered that there had been enough continuity to have successor liability, but the judge disagreed. So those repeat citations were downgraded, and the holding from the judge was that he could not, the new owner could not be held responsible for the prior owner's knowledge. So key takeaways here. OSHA is looking to expand the boundaries of PSM coverage, and the judge didn't stand in the way of that. The successor liability issue, we'll see a contrast with another decision, potential contrast with another decision in a minute. But the judge held that successor liability was not automatic, that despite a fairly continuous operations and workforce, that there was not sufficient management continuity for this to be successor liability. Despite that, our last point on this is you can be sure that OSHA we'll expect purchasers of refineries to know everything that was in prior PHAs, process safety information, and the like. So you may get a judge if you get citations from OSHA. You may be able to contest them and have a sympathetic judge that will toss out some of those successor liability claims, but you can look for OSHA on the ground when they're doing the inspections to be looking at even those documents created by a prior purchaser or the prior owner. All right, the next case here, Secretary versus Delic Refining. This is an even older case, but one that has more recent activity in it. Citations were issued in 2008 as part of the refinery NEP emphasis program. We had a similar situation where Delic had acquired the refinery just 3 years earlier. OSHA issued a series of serious citations. A number of them went to trial. They were all affirmed by the ALJ. That was in 2011. There was a 4-year gap waiting for OSHRC to rule on those. OSHRC largely upheld the ALJ's decision, a couple of modifications. And then we finally made it to a decision from a final decision in the case from the Fifth Circuit in December of 2016. So if you're keeping track of that, that's citations in late 2008 and a final resolution of the case in December 16. So you can certainly see a fairly long lead time between citations and ultimate resolution when these things get contentious. All right, just like in the Wynnewood case, successorship was a big issue here. It was combined with a statute of limitations issue. Two of the OSHA citations dealt with process hazard analyses and compliance audit recommendations. It seems that the prior owner had not completed or documented the completion of the responses to PHA and audit findings. When OSHA came in to do their inspection, they found evidence of this, namely a spreadsheet that did not have documentation of closure. And OSHA held Delic, the new owner, responsible for a series of PHA recommendations going back as far as 1994. There was a significant litigation on the statute of limitations and successor liability arguments at the trial level, and again in front of OSHRC. Both the ALJ and OSHRC rejected the employer's arguments on this topic, but when the case arrived at the Fifth Circuit, they overruled OSHRC and largely ignored the question of successor liability. So we don't have anything new to report there on that issue, but really decided the case based on statute of limitations. Much as the D.C. Circuit did in the Volks decision a few years ago, the Fifth Circuit took a pretty hard line on OSHA's 6-month statute of limitations. They said essentially that OSHA could not consider these very old violations to be continuing violations. The focus here of the Fifth Circuit was on when the violation occurs. So there's language that OSHA frequently uses that an employer has to promptly or timely document a response to PHA or audit findings. The court held fairly clearly that when that documentation is not done promptly or timely, it didn't identify a very specific time frame, but they said once it was no longer prompt or timely, that the statute of limitations would begin to run. So there was also a piece here where they talked about the fact that a continuing violation, you couldn't have a continuing violation in this context because the employer can reject the findings outright. So those are the real keys of the decision there. Takeaway on this, there is some shelter for purchasers of PSM-covered processes. You may not be held completely responsible for what the prior employer did or concluded in their PSM documents. I will flag again, though, that you can expect OSHA to probably continue concluding that they can hold you responsible for it. So be on the lookout if you ever have an ongoing OSHA inspection on this. The other issue that arose here was under mechanical integrity. We saw a very broad interpretation of the applicability of the PSM standard and its mechanical integrity provisions in this case. The equipment at issue was a positive pressure unit, essentially a fan in a control room that maintained positive pressure. OSHA took the very strong position that this was process equipment. The company disagreed, focused on the language in the application provision of the mechanical integrity portion of the standard, OSHA's guidance documents, and longstanding industry practice. Despite that, the ALJ, OSHRC, and the Fifth Circuit all sided with OSHA. So there were a variety of holdings here. It's a little hard to nail down exactly what the thread is that ties this PPU to process equipment. But some key factors that kept showing up were the fact that it was integral to the process, the fact that the operators that controlled the process were sitting in a building that was protected in some way by this positive pressure fan. All of the courts looked at the activity of the process in its entirety. They were not willing to limit the definition of process equipment to those pieces of equipment that touch chemicals or that actually are actively engaged in the flow of chemicals through pipes and vessels. And then there was also an element where the courts concluded that this could fall under the definition of a control, which is one of those specifically listed things that must be covered in a mechanical integrity program. So the takeaway from this one is look for very broad definitions of process equipment. I think it had been a previous widespread opinion in the industry that you could consider process equipment to be largely those things that touch the process or that were actively involved in controlling the movement of chemicals through the process. You can expect OSHA, and it seems at this point most of the courts, to take a different view and to apply this definition very, very widely. So you'll need to keep an eye on that for your mechanical integrity programs. One final finding, one final issue that arose in the Delic case related to management of change. OSHA had alleged that the application of a steam lance to cool a vessel, which was a common practice, that required an MOC. The LJ upheld that citation, but OSHRC rejected OSHA's holding on that and found that because it was a regular and recurring phenomenon that no MOC was required. So that's another important holding there as you're going out and checking to make sure that you're doing all the MOCs needed. That's something to keep an eye on. All right, I think we've covered these takeaways. We'll move right on to the last case, Secretary versus Bp Husky. Unlike the first two cases that had fairly significant holdings for OSHA, this case came out much better for the employer. There's going to be two primary things to talk about here. One is OSHA's use of a voluntary plant-wide audit to issue citations, and then also their conclusions related to Rageh. So we'll dig right in here. Sorry, we'll back up one slide here. As I flagged, this case had a very peculiar set of facts wherein the company had seemed to want to do the right thing, had hired an outside consultant to come in. They had reviewed the relief system there in the plant, had identified things that they thought that the plant should improve, some possible deficiencies or some possibilities where you could have releases or some inadequate relief. The plant was actively engaged in improving their relief system. And during this time where they were working on those improvements, OSHA shows up to do their inspection. Despite the fact that OSHA has a self-audit policy where they are supposed to not use these kinds of positive self-audits against an employer, they did. They essentially went right down the line. The findings in this audit just lifted the conclusions where the auditor said that perhaps a relief device was falling short of the API standard. OSHA just mirrored the conclusion and issued a series of willful violations that brought the penalty up to $3 million. So this is a very aggressive enforcement against the employer. The judge in this case, she rejected that those findings of willfulness. She did not explicitly throw them out because OSHA relied on the audit. Instead, she focused on the employer's state of mind, saw that the planned improvements, the activities that they were engaging in fact, showed the opposite of willfulness, that they were taking good faith steps to solve some problems. So good news for the employer, they did not end up with all of these willful citations. So that was a fairly significant result for the employer. The other piece here is going to be how OSHA used the Rageh gap. As I noted, they essentially went down the line of the consultant's recommendations and said, look, here's a gap between your relief system and API 520 or API 521. And OSHA considered those to be essentially almost per se violations. But the judge found very clearly that OSHA is not allowed to make certain industry standards prescriptive. She affirmed what we consider to be a long-term, a long-held view of the PSM standard, that employers can use their own internal standards so long as they can qualify as recognized and generally accepted good engineering practices, the focus on good engineering practices, that employers can do that, and OSHA cannot just come in and disagree because some other industry standard exists. So you can see on the slide here there were a number of different Rageh gap violations issued by OSHA that the judge vacated based on this view that OSHA is not allowed to make these things prescriptive. OSHA is also not allowed to dictate the timetable for implementing PHA recommendations. So this was a much better case for the employer. It's also currently on review with the Review Commission. As I said before, now that there are 3 commissioners, we could see a decision on it any day or in a few years. So we'll stay tuned for this one. And with that, we will move on to talk about OSHA's new ChemRef NEP.
All right, so now on to the enforcement side of the discussion. We've talked about some cases that have gone through inspections, citations, and litigation. Let's talk about what the next wave of enforcement inspections will look like in the process safety management context. Talk just real briefly about the history. OSHA initiated a petroleum refinery process safety management national emphasis program years ago, and through that process conducted very, very extensive PSM-focused inspections at every petroleum refinery in the United States. There were some interesting lessons learned out of that inspection program, and OSHA decided that they would first experiment with a pilot program to pull in the many hundreds or thousands of chemical manufacturing facilities to perform an abridged version of that PSM inspection program for chemical manufacturers, and found through that process that they were able to do quicker inspections with less resources with a similar set of enforcement results. And so the agency has now retooled that chemical facility process safety management national emphasis program to sweep in petroleum refineries and to do those less resource-driven inspections now in a second wave of refinery inspections. So this new program is really just a retooled version of the chemical facility PSM NEP. It's now going to be called the ChemRef NEP, or the Chemical Facilities Petroleum Refinery PSM National Emphasis Program. The new directive for this new emphasis program was launched on January 17th, 2017. Again, that magical week where so much seemed to happen just a few days before President Trump's inauguration, and this one effectively is continued to today. The new administration has not made any changes to the proposed launch of this emphasis program. The schedule involved an outreach by OSHA to the regulated community to talk about what they can expect under this new national emphasis program. And one of the major outcomes of that outreach, through meetings by OSHA, the PSM team at OSHA, with the regulated community, primarily through trade groups, trade associations, was a common feedback from the industry that, hey, you did this massive enforcement program in the refining industry years ago, and you've never published anything about your lessons learned. What are things that refineries should have taken away from that? What was the big focus of those inspections and enforcement actions? And what should employers be doing differently? And the agency agreed. It made sense that lessons learned really ought to be published before they advance this new second wave of inspections. And so they held the start of this emphasis program until that lessons learned document could be published. They did publish it this fall, and Micah is going to spend the tail end of this webinar talking through those lessons learned so that you all can prepare for the next wave of PSM NEP inspections. The inspections technically have begun. There have been very few actual programmed inspections under the new ChemRef NEP, but OSHA assures us that there have been some. I believe the answer is that there have been none at petroleum refineries, but some chemical facilities that were really undergoing the ongoing chemical facility NEP anyway have had inspections under this new program, but it's not really so new for the chemical facilities. For refineries, we are aware of at least one, maybe two, who have an inspection in OSHA's database that is coded as a ChemRef NEP. It actually shows up as Chem NEP in OSHA's IMUS database, but both of those inspections appear to have begun as a result of some other circumstance, either an employee complaint, an incident, or some other reason that OSHA showed up at the refinery and expanded the scope to be a chemical ChemRef NEP inspection. We're not aware of any in the refining industry that have started as programmed inspections. But nevertheless, the program is apparently off and running, and the agency is conducting inspections either programmed or expanded from non-programmed inspections as we speak. The big difference between the inspections that were done in the first wave for petroleum refineries and what has been going on for chemical facilities and what now will happen for both chemical facilities and petroleum refineries has been characterized by OSHA as the difference between a pop quiz and a final exam. The first wave of the refinery PSM NEP, I would say, was more like defending a thesis than a final exam, but it was certainly more broader in depth and in essentially every way than the chemical facility NEP and the new ChemRef NEP will be. Under the old refinery NEP, there was, prior to the start of the inspection, a 39-item document request was submitted, and then the agency, during the inspection, analyzed 98 questions. So these were sort of a fixed set of questions analyzing essentially every element of compliance under the PSM program in a broad range of process units at the refinery. The chemical facility NEP and now the ChemRef NEP is characterized as a pop quiz style inspection because there's no questions asked in advance, no questionnaire, no requests before the start of the inspection, and it's limited to 15 as opposed to 98 questions that are analyzed. So it's a sampling of elements And we're also seeing that the team that OSHA uses to conduct these inspections is very different. During the refinery NEP, it was a minimum of 4 compliance officers, all with special levels of training in process safety management, to now a single compliance officer may conduct the new ChemRef NEP inspections. Similarly, in the refinery NEP first wave, we saw at least 3 process units were covered by the inspection, and every element of the PSM program was covered in those 98 questions for review. Now you're more likely to see a single process unit, 1 compliance officer looking at a subset of PSM elements as opposed to every element. We know that unlike the prior refinery NEP that sought thousands of pages, essentially a complete compendium of your process safety information, your PHAs from many years back with recommendations, follow-up actions, etc., essentially all of your related mechanical integrity records. The new NEP is going to be essentially a spot check of PSM records. Again, no pre-inspection questionnaire, shorter dynamic question list rather than the old very long static list. The dynamic list will not be made publicly available, and it will change periodically. I think we've seen once a year. We were expecting more of a rotation during the chemical facility NEP, but it looked like that was changing anecdotally, in my experience, about once a year. The other thing that we're expecting to see is, a new list, right? We saw for the refinery NEP, it was every refinery in the country, all done during the short period of time that program lasted, 2 or 3 years, I think it was. Now the idea is the refineries will be lumped in with the hundreds and thousands of chemical manufacturing facilities in the country and visited on various varying degrees of frequency depending on how many of those types of facilities you have in your region or in your area. The last target that I heard from OSHA is that they expect to do approximately 230 ChemRef NEP inspections each year, which is spread across their many area offices all across the country over the course of the year. We do expect, however, that OSHA will front-load petroleum refineries. This is an indication we've gotten from the agency during the outreach for the program. You can expect the refineries to be somewhat front-loaded in this process. So again, maybe over the next 2 or 3 or 4 years, just about every refinery in the country. And I say just about because if you are a VPP participating entity, you are supposed to be precluded, exempted from this program, at least on the programmed side of the inspection. If OSHA has some other reason to be at your facility, for example, an incident employee complaint or referral, they can expand to do one of these ChemRef NEP inspections even at the VPP facilities. And it's hard to go 3 or 4 years at a refinery without an employee complaint or some incident that OSHA thinks is significant enough to come in and take a look. A couple other interesting points about the new NEP. We expect it to be a lot less resource intensive. Interesting distinction here. Well, lessons from the prior refinery NEP. The average penalty per inspection was about $77,000. That was, of course, under the old penalty scheme. Expect those to be about 80% higher, and through some other policy changes, even perhaps higher than that on a per inspection basis. And you can see some of the other data here. Mike is going to talk about these lessons learned in particular. I think it's always an interesting place to go and look is what have been the categories that OSHA has focused on. And Micah is going to get into great detail about that, but you can see the data here that really mechanical integrity, process safety information, and operating procedures made up well more than half of these. Throw in PHAs and you're talking about most of the ball game. Everything else spread around those 1 to less than 10%, but a real heavy focus on mechanical integrity, process safety information, and both of those categories, incidentally, are really this new worldview of what Reggae means and how it applies, and Mike is going to talk about that in some detail here right now. So that's what's to be expected from the new NEP. So let's look historically at what we can learn from the old NEP.
All right. So as Eric noted, at the urging of industry, OSHA published their lessons learned so that we could all share in the wisdom that OSHA had gained from their last go-around on this. If we go back one slide, when we get to, in a minute, we will look at the things that OSHA highlighted in their lessons learned. If you look at the top, the bold elements here, these are the 5 that OSHA talked about. In their lessons learned, they didn't go into detail and talk much at all about the other PSM elements. So it's an interesting fact that they didn't talk about these other elements. You know, we may take this to mean that OSHA will perhaps not have so many questions related to things like incident investigations, contractors, compliance audits, and the like. I don't think that we can expect to see zero enforcement on those in this next round of the NEP, but I do think that it's worth noting that when OSHA talks about their lessons learned, that they really talked almost exclusively about these top 5 categories: so mechanical integrity, process safety information, operating procedures, process hazard analyses, and management of change. So we'll go through what they learned on each of those topics in just a moment here. All right. The first one to talk about here is process safety information. This was right near the top of their list. We have the main thing that we noticed in the first round of the refinery NEP was a real focus on Rageh. And as Eric highlighted, they followed this up with the new interpretations in 2015 and then the revised interpretation in 2016 after they got pushed back on that letter. OSHA has been taking the approach, and we saw this in the cases as well as in their interpretation letter, that they intend to apply the Rageh that they prefer when they do these enforcement actions. During the refining NEP, we saw a very widespread range of areas specifically for process safety information where OSHA was trying to apply Rageh. The 2 most prominent were for relief systems and in facility siting. Some examples of how they cited employers for alleged Rageh deficiencies in relief systems. If you had a missing or an undersized relief device, that is, if you had a vessel and OSHA interpreted API 520 to say you needed a relief device on that, then they were going to issue a citation for failing to document Rageh appropriately, which is kind of a backwards way of approaching the issue. They essentially found something they didn't like and said, well, you violated the Rageh. Another one was if the back pressure on a relief device was higher than the OSHA interpreted the API standard to say, they would issue a Rageh citation there. Same for anything they determined to be an incorrect set points or an intervening valve or a car seal between a vessel and a relief device. So we saw there OSHA finding very specific instances of equipment they didn't like, settings that they didn't like, something that they disagreed with. They would find a provision in an API standard that they thought applied and say, look, you failed to appropriately document Rageh. Here's your citation. We'll skip to the last point here because it's intertwined with this Rageh discussion. OSHA spent a lot of time on relief systems in their in the NEP. So even when they weren't citing these things for Rageh, they were citing people for not having appropriate documentation, for not having the right relief system in there, enough relief capacity. It was a real big focus. So the other item that they highlighted in their lessons learned was piping and instrument diagrams, the PNIDs. This was a recurring issue. It was fairly rare that we would see an employer get a set of NEP citations and not have a P&ID citation. As you all know, there are hundreds, if not thousands, of these, all with on their own tens or hundreds of data points. And so it's, I'm sure you're familiar with how easy it is to find one of these that is out of date or is missing one particular element or something like that. OSHA, during the NEP, would take a set of these, go walk them down, and if they couldn't find a valve that was on there, or if they couldn't find a valve tag that they wanted to see out there, you'd get a citation for that. So frequent citations here were field tags that didn't match the P&ID notations, or if there was ever an inconsistent use of a notation system. You know, many facilities have gone through a change at a certain point where they went through a renaming process. If anything was mismatched in the field and on the P&IDs, you could expect to get a citation on that. All right. The next category was process hazard analyses. So one of the main things that we saw, and we saw this in the cases discussed previously, was OSHA focused a lot on the resolution of recommendations, and they, in particular, they characterized their violations as employers having a faulty system. So if they came in and they found that you had missed responding to one of the recommendations, they alleged that you had a system that was deficient. Your system was not appropriate for closing these things out because you were too late. Maybe you missed one. Maybe you misplaced the documentation. But regardless, your system was faulty. So that was the overall approach. One little tidbit that we thought was worth highlighting here was how OSHA said that employers need to respond to these recommendations. In their lessons learned, they say when you have a PHA recommendation, the employer has at most two choices. You either must implement the recommendation or document that there is no actual hazard. So on its face, that seems fairly reasonable, but if we think about it a little bit more, we can probably think of some situations where you may have had a PHA recommendation that you wanted to respond to somewhere in between those two things. Perhaps you disagreed with a recommendation, particularly if it was a very specific recommendation to implement some kind of a control or some kind of a safety process that management thought was inappropriate or overbroad or ineffective. You may have concluded that there was something worth addressing here, but you didn't agree with the team's recommendation on how to address it. So in that situation, you might respond to the recommendation, you might implement a safety improvement, but not the recommendation itself. The way that OSHA framed this, you can see where they might find room to disagree with your conclusion that you wanted to implement a safety improvement that didn't match the recommendation, but you certainly weren't in a position to document that there was no actual hazard. So we highlighted this primarily just to say keep an eye on these, and you can expect OSHA to read fairly carefully in your PHA recommendations and in your documented responses to them. You can expect some scrutiny on how you responded to those. Another key area that OSHA cited under the PHA section of the standard was facility citing. This was most refineries that we saw received a facility citation. They applied to any number of factual circumstances. Anytime you had a temporary structure, even one that was considered unoccupied, you could probably expect to have a citation there if you didn't do a thorough enough analysis there, or if you allowed employees to be inside that structure for really any period of time. Other frequently cited fact patterns were issues related to equipment spacing, vehicle impacts. These were issued very often. If OSHA thought that there should have been a bollard or something separating a tank or a vessel or a pipe from a vehicle area, you could expect to receive a facility citation. Also, anything related to what OSHA considered inadequate protection in control rooms. If OSHA thought your operators in the control rooms were at risk, you were probably going to get a facility citation. So OSHA, in their lessons learned, said quite clearly that they thought that refineries had not made enough progress on facility siting. So we think that this will be another thing to watch for in this new version of the NEP. The last one here is human factors. This seems to act as a catch-all. If OSHA found something that they didn't like, but couldn't quite find a section of the PSM standard that applied, it seemed that they would use human factors to cite it. So if you were requiring an employee to go do something, they thought it was dangerous, it was a decent chance that you'd get a human factors violation there. All right, next one, operating procedures. So one of the key findings that I saw there was anytime that there was a mismatch in the operator practices and the operating procedures, you were going to see a citation. So during the refining NEP, there were extensive employee interviews. You could almost count on at least one employee saying, sitting down with a procedure saying, well, I've never seen that before, or that's not exactly how we do it. And in most of those cases, you saw OSHA issue a citation because the practice didn't match with the written operating procedure. They really expected near perfection with the operating procedure, so even technical inaccuracies, maybe you missed a valve number by one or some small thing that you could probably consider to be a typographical error, you were likely to see that as an operating procedures violation. The other frequent issue that we saw was when OSHA thought there should be an operating procedure, the employer thought there shouldn't be, maybe because this was something done every 2 hours or so frequently that it was covered in operator training. We saw a lot of citations issued there. A lot of scrutiny on emergency shutdown procedures, particularly when OSHA thought that there was a lack of specificity. Maybe the conditions requiring shutdown weren't identified, or that it wasn't clear in writing who had shutdown authority. Those were some key issues there. Safe work practices was also frequently cited, most often dealing with unit entries, particularly for vehicles, but also sometimes for contractors. Findings in mechanical integrity, as we've already talked about, a lot of Rageh citations here. We saw this both when OSHA didn't like the procedures that you had in place. They thought they were inadequate. Maybe if inspections weren't done as frequently as OSHA wanted to see them, they would cite you under the Rageh provision. Or even if you had an equipment deficiency, they would say, look, you're not following Rageh because your pipe is too thin, based on your analysis of API 570. So Rageh is woven throughout almost all of the mechanical integrity citations, so keep an eye on that. Make sure that you are clearly documenting what is the basis for your inspection program, for your minimum thicknesses, all things like that. Also of note, we saw this during the NEP and also since then, OSHA compliance officers seem to have a difficult time either understanding or accepting risk-based inspection. They will go to API 570 and see that the fixed interval for a Class 1 pipe is every 5 years. You may be under an RBI program, and for this particular pipe, you're at an 8 or a 10 or a 12-year interval. You can almost count on, you have a better than even chance of the compliance officer calling that out, issuing a citation on as a Rageh violation. We deal with these frequently. We're constantly reminding OSHA that RVI is acceptable, that it's better than fixed interval many times, but we continue to see these citations, so that's something to watch out for. All right, the last section that OSHA dealt with, there are two more on mechanical integrity. The compliance officers seem to have a fascination with growing pipes. So if they felt that your inspection data was showing that some kind of a weird trend, so if you saw any amount of an increase in thickness as a result of your ultrasonic testing, and you didn't document sufficiently, that you went back and checked things and that this pipe isn't actually growing and that we don't have a horribly flawed system for inspections, you could see a citation there. All right, now last one. The last category, management of change. We've got a lot of specific situations here that OSHA found where they thought there should be management change. The real high-level takeaway is OSHA wants to see an MOC for just about everything. They tended to disagree when employers were doing what they thought to be replacement in kind. You'll remember in the Delic case, we talked about how OSHA issued a citation saying that you needed an MOC when you had this regular and recurring application of steam lances. OSHA thought that needed an MOC. They also cited employers for changing a building. Even if you were upgrading ventilation, moving an exit, just changing the location of a door, they wanted to see an MOC there. And then the last thing worth highlighting there is the fact that OSHA really dug in on temporary MOCs. They were looking very closely for temporary MOCs that had gone on for longer than they thought was appropriate for a temporary MOC, or for letting it expire, not renewing it according to the timetable you set up. So keep an eye on those temporary MOCs. All right, last one here. These are non-PSM. A couple of things that we saw pop up really frequently that we thought were concerning in the refining NEP. Electrical classification. You probably have electrical classification drawings. OSHA may or may not agree with how you classified certain areas. They will certainly look at what you designated as Class 1 Division 2 and see what you're doing in those areas, how you're letting vehicles in, how you're letting other equipment and work happen in there. So keep a close eye on that. OSHA will probably be back looking at those some more. HAZCOM, we saw some odd citations related to improper or inadequate labeling of containers, vessels, not keeping a list of what are the hazardous chemicals on site. Seemed like an odd application of HAZCOM to these operating units where people are certainly not out there opening up a cat cracker, but OSHA seemed to be applying the HAZCOM standard as if they would. So we may see some more strange misapplications of the HAZCOM standard. And last one, PPE. Of course, there's lots of PPE citations issued. These were flagged in OSHA's lessons learned. The way we saw this develop was if you had an employee injury, OSHA just about presumed that you should have known ahead of time that PPE was needed in that situation. This is an area that we've seen in litigation a fair amount of success in convincing OSHA, sometimes through a little effort, sometimes through a lot of effort, that their citation was not as good as they thought it was, that employers do not have all-encompassing knowledge of the future and can predict all of these things. So if OSHA does say that you should have known that employees needed PPE because an incident occurred, there may be some room for arguing with OSHA on that. And so with that, we are at the end here, and I'll let Eric close us out.
All right. Well, thanks everybody for sticking with us for a long program today. We are relieved, and we're going to go have a whiskey and a cigar to celebrate the end of the 2017 OSHA webinar series, and I'm very excited to announce the 2018 OSHA webinar series. And we've taken our best crack at what's going to be relevant and timely for the next 12 months, and some of that may change over the course of the year, but we'd encourage you all to sign up for the next year's webinars and join us for that. You should see an announcement coming out about that with links and all sorts of good stuff, and I think it was in an email we sent you today with a copy of the slides. So please check that out and plan to join us for those, and as always, take a look at our blog as well, the OSHA Defense Report. I see that we do have some questions. We'll tackle some of these for those that want to stick around. Otherwise, thanks everybody for joining us, and I recognize a lot of names here of folks that joined us for many of the programs over the course of the year, and we greatly appreciate your interest in the program, and we hope that you join us again next year. There's a good question here in talking about the rulemaking, or the likely rulemaking that EPA will advance to reevaluate the RMP amendments. What are the most vulnerable elements of the RMP rule to repeal? My sense is, at this moment in time, the most vulnerable elements are all of them, that it is likely to be a complete sort of withdrawal, rescinding of the amendments that were advanced. If it does happen to be a piecemeal type of approach to this, I think the two most likely, most vulnerable elements are the safer alternatives analysis and the extent and degree of public sharing of information are the two most likely candidates for being peeled back or individually carved out. But my sense right now, what I've been hearing, is that the most likely outcome is that the amendments, that entire rule that includes those 6 elements, would be struck collectively. There's either a question or a comment here about the targeting under the new emphasis program, that OSHA is setting up the site targeting divided into 2 buckets, or buckets of targets. One is chemicals, ammonia, other, and petroleum refining. They're apparently looking to have different inspection numbers for each bucket. Do you have an opinion on that meeting the neutral and objective test for site targeting when certain industries are disproportionately targeted by wide margins? I think that the concept here is that the different balance of the types of facilities that will be targeted will depend on the balance of those types of facilities that exist in the different regions. So I don't think this approach, I'd have to think about this a little bit more, but my instinct here is that this is not the sort of thing that takes you out of the neutral inspection criteria. And the point of this question, for those that may not know, is whether this would be really a permissible demonstration of administrative probable cause to proceed with an inspection without a warrant. To have administrative probable cause, you either need to have evidence of some specific violative condition at a specific workplace, or use a neutral selection criteria, which is generally what the national and regional emphasis programs are, where they identify an industry or a particular hazard and then identify individual industries that may have those types of hazards. Here, frankly, I don't see this as terribly different than using a regional emphasis program, that takes something out of the sort of neutral selection criteria, because you're only targeting employers in the Southeast where there's a significant amount of auto manufacturing and not in the Midwest for whatever reason. I don't see this as terribly different than that. This is basically a policy decision about where resources will be directed for enforcement, but it is a really interesting concept, and I'll give that some thought, and I'll reach out to my friend that asked the question and talk some more about that. If there's something interesting there, maybe we'll write a blog article about it. Another question here about will Epa Rmp align its Reggae Gaap analysis with OSHA's in the revision? That's a really great question, and one of the big things that we've been struggling with and raising as concerns as EPA moved through its incredibly rushed rulemaking process, leaving OSHA behind, is that these two programs are supposed to work hand in hand. And there's an incredible amount of guidance out there, preambles to the legislation on the EPA side and the regulatory side on the OSHA side that says compliance with one of these programs shall be considered compliance with the other. And of course, what I mean by these programs, meaning if you have a management of change program that meets the requirements of OSHA's PSM standard, that is supposed to be acceptable to EPA. They're not supposed to diverge in these requirements. And by EPA rushing ahead with a rule that introduces all kinds of new elements to the program, new interpretations to the program, really splits up the ability to comply with one and automatically comply with the other. So the question here about EPA aligning Reggae Gaap with OSHA in its revision, I think to the extent that Reggae Gaap has been reinterpreted by EPA's rule, by rescinding that, it would take it back to the status quo prior to the amendments, which that status quo was that compliance with one was compliance with the other. So I think we could expect that level of alignment. There has also been OSHA changing its view of Reggae Gaap through interpretation letters, but I think there's good law out there that employers can rely on formal interpretations from one agency or the other in this area because they are supposed to be aligned. So I do think we can expect alignment at the end of the rulemaking process. I get a question here that is not related to PSM RMP, but it's timely, so I'll address it anyway. Any update on the OSHA electronic record-keeping rule with the first deadline to submit data this Friday, December 15th? No changes to that. December 15th looks like it's going to stick, so I think you should anticipate the need to submit that data this week. I think we can, just as we can expect EPA to move forward to rescind or amend the RMP rule, I think it is all but guaranteed that OSHA is going to introduce a notice of proposed rulemaking to either rescind or significantly amend the electronic record keeping in advance of next year's data submission. But this year's submission looks like it's going to happen, and it's, we're 3 days away from the deadline. So make sure you understand whether you're covered, understand what data needs to be submitted, and you understand that if you're in a state plan state, whether that state plan has adopted the rule yet. And if you have questions about any of that, please do call us. We're fielding multiple questions a day on this rule. We're happy to talk it through with you. I would be surprised if there was a question you have that we haven't fielded in the last month, so please reach out if you have any of those types of questions.
I had another question on going back to process safety information, relief systems, and car seals. A question about whether OSHA has a concern about managing valves that are part of relief piping with car seal system. The answer to that is yes. OSHA would frequently talk about just car seals as its own separate issue without necessarily tying it to relief systems. So in some ways it makes sense to deal with them separately. On relief systems, and they tied this in some ways to the industry standards, there was always concern expressed if there was some possibility of blocking access to the relief valves from a process vessel. So if you have a valve or anything that could possibly prevent a vessel from leaving to that relief valve, OSHA was concerned about that. As you know, many employers will use if you do feel the need to have an intervening valve, that many employers will use a car seal system to essentially apply an administrative control to help ensure that things are kept in the right position. Of course, if you need to have that valve there, that seems to be the right approach. OSHA is okay with that, but they were very, very picky in the refining NEP about how these programs were administered. So if they went out and found a missing car seal, if they found a PNID that didn't have a car seal notation on it, they tended to issue citations in all of those instances. So the takeaway, I think, is perfection is the best way to avoid any citations. So if you can avoid having these potential blockages in your relief system, that's the best. If you have these valves that exist, make sure you have a system that ensures that they are always open when needed and that it is well documented in all of the various ways that OSHA would want to see it. And they will try to find all of your tiny errors, whether it's written or in the field.
All right, two last questions here that I think I can tackle with one answer. First one is, do I foresee or do we foresee any changes to the threshold quantity limits for PSM coverage currently listed in the PSM standard, OSHA's PSM standard? Another question about a prediction for what we can expect in terms of the PSM rulemaking or PSM agenda altogether under Scott Mugno, whose confirmation hearing was held last week. A vote is apparently scheduled for this week, although it may not happen this week, but will happen soon, and we can anticipate that he will be the next Assistant Secretary of Labor for OSHA. My answer to that question, both of those questions, is I don't expect to see any movement really at all in the PSM rulemaking context during this administration. And the reason I say that is the first regulatory agenda that we talked about earlier that moved the PSM rulemaking to the long-term actions, that was produced, predating Scott Mugno as Assistant Secretary, but post-dating Alex Acosta as the Secretary of Labor. And Secretary Acosta weighed in on the regulatory priorities for the agencies, all the agencies under his purview at Labor, and determined that advancing the PSM amendments that started during the previous administration were not a present priority for this administration, that in fact they are a long-term action, meaning don't expect to see any changes. I think it also makes sense that regardless of who's running the show at OSHA, that they're going to pay attention to what EPA does, because really RMP and PSM ought to move together. They ought to be synchronized. They ought to be consistent. And right now there's some question about what the future of RMP looks like. So I think by the time that question is settled through a rulemaking process, we're going to be pretty late in the game in a Trump administration for any significant change in the PSM rule to take place. So I think not because of anything that Scott Mugno may believe or any agenda he may have as it relates to PSM, I just don't expect to see any changes in PSM for all of those reasons, independent of Scott Mugno's thoughts about process safety. So once again, let me thank everybody for joining us today. Really interesting discussion if you're a big OSHA nerd like I am on these issues, and I'd encourage you all to continue the discussion. If you have any follow-up questions, please don't hesitate to reach out to us. Email, phone, our contact information is here. We love to talk about this stuff, and we'd love to be a resource to you, and we do hope that you join us next year for the 2018 webinar series, and in the interim, happy holidays and Happy New Year.